Syncopated rhythms, electronic dreams, AI music.
Thank you all for coming out and being online around the world, I guess, to see this. We have a great lineup today. We're going to start just sort of to get you situated here with remarks from the Copyright Office, and we'll introduce the speaker in just a moment. And then following that 15 minutes or so, we will have an open panel discussion for about a half an hour, followed by questions. So this is a great topic, and we'll start off, as I said, with Miriam Lord. But before we introduce her, I want to let you know who's sitting next to me. This is Chris McMurtry, and Chris is a musician and a technologist, I would say, who you'll hear more about from Nashville. Okay. Then we have Mike Mattioli to his left, and Mike is a professor of law and a Lewis Nizer faculty fellow at this fine establishment, Maurer School of Law. I'm, by the way, Robert MEITUS adjunct professor of law. I don't have one of those fellow names after me. I get paid less. Okay, and then we have Marshall Leifer in the best location over there online, and he also is a fellow. He's a distinguished scholar of intellectual property law, university fellow from Paris, France. Hey, Marshall. Okay, so now to our first featured speaker from the Copyright Office, and she must be chilly. I think it's in the 40s or 50s out there. She's out in front of it's like the Library of Congress. Miriam Lord is the Associate Register of Copyrights and Director of Public Information and Education for the U.S. Copyright Office. She was appointed to that position May 8th, 2022. And she oversees the Office of Public Information and Education, which provides authoritative information about copyright law to the public, implements the office's communication plans, and many other important things. She has been focusing a lot on AI, and her office has over the last few years. And we're going to hand it over to her to tell us what's up at the Copyright Office.
All right, so my name is Miriam Lord from the Copyright Office in DC, and I just want to thank you again for the opportunity to present today on the work we're doing on artificial intelligence in the U.S. Copyright Office. And I'll just jump in. And I'll just note that the Copyright Office in the United States has an unusual role. So we're part of the legislative branch of government with the responsibility of advising Congress, the courts, and other government agencies on copyright law and policy. So yes, this behind me is right down the road from where I'm at right now is the James Madison building at the Library of Congress. So the office also administers the U.S. copyright system, which includes registering claims to copyright. Registration is not required for copyright protection, but it does confer substantial benefits. So most commercially valuable works are registered. We receive about 500,000 applications every year, covering millions of works because there are some group options. Unlike U.S. law, unlike registration systems in other countries, the office is charged with examining registration applications and determining whether those works are protectable by copyright. So just a brief summary, early last year about AI, we announced a broad initiative to examine the copyright implications of the current forms of generative AI and issued guidance on how to register works that incorporate AI-generated content. So we instructed applicants to disclaim protection for any content that was more than de minimis and briefly identify the human creativity involved. Since then, we've held numerous events to gather input from knowledgeable and interested parties, attended by thousands of people. It's included listening sessions, webinars, and individual meetings. And in August of last year, we published what's called a notice of inquiry, seeking public comment on the full range of copyright protections and issues that had been raised. So we received over 10,000 comments from every state, including from Indiana, and from a mix of authors and actors, and artists, publishers, producers, musicians, legal scholars, technology companies, sports leagues, and even a class of middle school students. So this reflecting the high level of global interest in this topic. Comments were also submitted from 66 different countries. So what was this about? The questions we posed can be grouped into three main topics. First, the use of copyrighted works to train AI models, including the allocation of any potential liability. Second, the copyrightability of material generated using AI. Third, AI outputs that imitate the identity of human artists. So let me provide some detail on those topics in reverse order. And I'll just take you through a couple of slides. So this is the background of the initiative and the items that I mentioned. So we're going to be attacking this in different parts, and I'm going to go through those parts. So first is digital replicas. So performing artists in particular have raised the alarm about AI-generated works imitating their likenesses, their voices, their style. There's been a lot of publicity about deepfakes, such as the duet appearing to be by Drake and The Weeknd, and AI-generated versions of Tom Hanks and Taylor Swift used without permission to sell products, and let's just say for less savory purposes too. In the United States, this kind of conduct is generally not covered by copyright law, but there are various state laws that could apply, dealing with rights of publicity and privacy or unfair competition. So we've asked, should there be a federal law specifically tailored to the AI context and providing greater clarity and uniformity? This is what we'll be exploring. So next, as to the copyrightability of outputs of artificial intelligence, the office has been early to develop standards due to our role in examining applications. In fact, the office serves as sort of a natural laboratory in evaluating the scope of AI-generated material, the copyright in that material. So the first generative AI application we received was 5 years ago. It was essentially a test case. You see it on the screen here. It's a copyright claim in a work of visual art. It's not music. That's what we have right now. A claim to have been created entirely by AI with no human involvement. We refused registration on the ground that human authorship is required for copyright protection. And in August, the federal district court in DC issued a decision agreeing with us, and that case is currently on appeal. Other applications have had less clear-cut sets of facts involving a mixture of human and AI contributions. To date, our examiners have issued over 200 registrations for works that contain AI-generated material when appropriate disclaimers have been made. But there are 3 highly publicized cases where we have either narrowed the scope of registration or where our review board has affirmed denials of registration, and I'll walk through those now. Right. One involved a comic book created using images produced by generative AI. This is what you see on the screen. We concluded after examination that copyright could cover only the human applicant's contribution, the text that's in here, and the selection, coordination, and arrangement of the text and images, but not the images themselves. In the 2 other cases, the human contribution was less clearly separable with either the human altering AI-generated content or vice versa. So I'll take you through a couple of those. In the first one, here's a photograph. The photograph is taken by a human. It's fed into an AI, a generative AI model. A style is applied to it, the style in Van Gogh's Starry Night. The image that results on the right is the resulting image. Our finding is that the image itself is copyrightable, of course, but that there's not sufficient control in the final outcome of the image. The decisions made were the decisions made by the computer and not the human. Second case, it's the flip. So the first image is generated by an AI technology, and the applicant made additional changes following the AI generation. Unfortunately, this particular applicant did not disclose or disclaim the original piece and show us what he added to the piece. And so although we gave him that option, he did not take it, so we refused our registration. So here's the essential question raised in these more complex scenarios. When and how can a human exert enough control over the expressive elements in the work generated by AI to constitute authorship under copyright law? In other words, when does AI become a tool that reflects the human's creativity rather than becoming the source itself of the expressive elements required? So we continue to draw these lines case by case in the examination process, and eventually the courts will weigh in as well. And this is not new to copyright law. This is how lines are drawn in copyright law. So just briefly, because I know that it's on the minds, there are infringement-related issues that we are handling as well. So this is the most contentious set of issues. It's the subject of considerable controversy and litigation, and around 20 lawsuits have been filed in U.S. courts. Some of them are class actions. I'm sure you've heard about them in the press. In our notice of inquiry and in our study, we're asking, does employing copyrighted materials to train generative AI systems constitute infringement? And if so, in what circumstance? Does it qualify as fair use under U.S. law? Of course, fair use analysis is complex. It requires the weighing of multiple factors in light of all the circumstances. There are several leading precedents to apply and interpret, notably the Google Books case in the Second Circuit and the Warhol v. Goldsmith case in the Supreme Court. Copying for purposes of internal analysis has been held to be fair in a number of cases, but at the same time, the impact on the actual and potential market for the copyrighted work can be an important factor. We've asked additional follow-up questions. To the extent that consent and/or compensation is required, how could this feasibly be accomplished, given the volume and the variety of the works involved? Can it be done through direct licensing from copyright owners, some of which is already taking place, or through collective licensing? Or would a new form of compulsory license be desirable? As a practical matter, how can copyright owners find out whether their works have been used in machine learning? What information about the process is retained by AI developers? And what level of record keeping and public transparency is appropriate or feasible? And if copyright owners are given the ability to either opt in or opt out of inclusion in training materials, how would that work, especially for individual creators? So finally, our study considers how to allocate potential liability. Who should ultimately be responsible for any acts of infringement? The assembler of the training material, the entity developing or offering the technological tools, or the users of those tools? So the ultimate goal is one of balance. We want to find a way forward that promotes rather than inhibits the development of this exciting and valuable technology, but also ensuring human creativity can continue to thrive. Of course, this is easier said than done, and these are without a doubt complex and challenging questions. And as we move forward, we know we can't confine our attention within US borders. Since AI systems are developed and deployed internationally, using content from all over the world, we need to be aware of developments elsewhere. While everyone shares the same goal of balance, we're seeing some similarities, but also some divergence in how to achieve it. So our study asks whether any approaches in other countries should be adopted or avoided in the United States. But these are still very early days, and it remains to be seen how laws in other jurisdictions would be interpreted and applied there. So other updates from DC, we're in the Copyright Office. We're not the only ones in Washington evaluating the impacts of generative AI. Congress has also been busy with AI-related activities. They've held hearings on various aspects of AI, and to date, almost 30 separate pieces of legislation have been introduced, including on the issue of digital replicas. The Biden administration in October issued an executive order on the safe, secure, and trustworthy development and use of artificial intelligence. On copyright issues, it instructs the director of the Patent and Trademark Office in the executive branch to consult with the Copyright Office after publication of our report and recommend potential executive actions. Other agencies have been active too. The Federal Trade Commission has issued a call for public comment on a proposed rulemaking that would prohibit the impersonation of an individual through AI-enabled deepfakes. And the Federal Election Commission is considering a rulemaking to regulate the use of AI in political ads. So what's next? We plan to issue a report in several sections, analyzing the issues and making recommendations as to any appropriate legislative or regulatory action. Given the activity in Congress already, the first section will focus on the digital replicas topic and will be published this spring. Second section will publish in the summer, will address the copyrightability of output. Later sections will turn to the topic of training AI models on the copyrighted works, as well as licensing considerations and liability issues. And our goal is to finalize the whole report by the end of our fiscal year. Separately, we're going to publish an update to our compendium of U.S. Copyright Office practices, which further guidance and examples relating to the registration of works and incorporating AI-generated material. In addition, we've brought together a group of government and academic economists to discuss the economic aspects of the intersection of copyright and AI. Later this year, we're going to publish the group's proposed research agenda. And then finally, we'll continue to engage internationally, of course. While all of these approaches don't have to be the same from country to country, it's important for them to be compatible so that we don't erect unnecessary barriers to cross-border commerce and communication. And informal discussion and sharing of ideas and experiences, both at home and abroad, can lead to a beneficial level of de facto understanding and harmonization before any consideration of global norm setting. So I'm going to leave you with some information about how to reach out to the Copyright Office about not only artificial intelligence, but anything in the music space, anything in the creator space, anything that you need. This is an office full of people who deeply care about the creative community and the user community. We really want people to understand copyright law, to be able to navigate these things. And we'll encourage you to follow us and stay up to date on what the office is doing by subscribing to our press releases, our newsnets, as well as checking out the materials that we have for various communities, from the academic to the music to the user to the technology side of things. So I'll stop sharing for there. And I'll just thank you for all of your time today. It's such a pleasure to be here. I'm sorry I couldn't be there in person, but I look forward to hearing the rest of the panel and wish you the best conference. Thanks.
Thank you, Miriam. So I'll start by asking Marshall then, because we should make clear that the Copyright Office's general policy is they will not answer questions afterwards. So we can speculate what they might say or what we think about what Miriam was talking about. And my first question is any general reactions, Marshall, and we'll go around the panel here to what Miriam did talk about. I think there's two general things to think about just to situate this conversation today. It's protecting works that use AI in their creation. And on the flip side of that coin is protecting human copyrighted works, if you might use the term, against or from infringement by AI-related technology. So what were your thoughts, Marshall?
Well, my thoughts really relate to the report that they're doing, and I'm going to say something that's totally obvious. They're really covering the waterfront here. It's what a task they're going to do, and I can't wait when it comes out, particularly in the summer. But I was also surprised that I didn't realize that they're doing work on lookalikes and sound-alikes as well in their deliberations in this report. But anyway, what an enormous task.
So any other comments, Mike or Chris, on it? We don't need to go into that. We can jump right into our questions, but any comments? Okay. So my first question to the panel is really, in seeking copyright protection of AI-assisted works, to what degree are prompts or other similar human instructions enough to form the basis of copyright protection? Michael or Marshall, do you want to take that one? Like, what is it? Because it's not the AI-created works. It's clear the Copyright Office has already stated that. What about the human prompts or instructions to the AI?
Well, the Copyright Office has taken a perfectly reasonable and understandable position on this. They have to make a decision on the extent of protectability. If they didn't, I think chaos would reign. And so we're going to find out a little bit later in time. Generally, the idea that if you just construct the prompt itself, this is not a copyrightable event. And I think for the most part, this probably is a very sensible thing. On the other hand, I could imagine situations in which the prompt becomes so complicated with reiterations and the like that this would be something of interest to copyright, would be copyrightable in itself. However, I don't think that this is would be a practical way to go at the moment in which the Copyright Office finds itself in this context. But I don't see anything that might exclude, in some instances, a sufficiently developed prompt, which has causal implications. You see, it's not totally done by by the computer itself. I mean, it has causal implications because of the way the prompt is structured. Anyway, that's just general thought on that.
Yeah, I'll jump in. I agree with everything Marshall said. I would also say that to the extent copyright law is applied to the prompt, I don't see any formal thing that would stop copyright from protecting a sufficiently creative prompt. The bar is pretty low for copyright protection and creativity. But I'm thinking, what are the practical outcomes if there is copyright that applies to a prompt? First of all, when we use online services like ChatGPT or Google Gemini or others, we're agreeing to an end user license agreement. So is the AI service provider just going to work into its end user license agreement terms that say any prompts that you submit to our AI will be licensed to Google or Anthropic or whoever it is? So there could just be licensing that's worked into that model. Secondly, if copyright protection doesn't apply, maybe people will just be more secretive about their prompts. So I'm always interested to think not just what does the law have to say about this, but what's the practical impact? If there is or there isn't protection, what is it actually going to mean? So those are some quick thoughts.
So I'm going to move to Chris with a follow-up question. But first, I want to ask this. Do you see this, Marshall or Mike, sort of similar to public domain works where Bach or Beethoven, is not copyrightable if you just copy it onto a sheet music, but if you make an arrangement, a new choral arrangement, it would be the copyrightable material that the human adds to that original music. Do you see that as a valuable comparison?
Strictly speaking, Marshall, if you want to jump in at any point, feel free to. Sure. My initial thought is if we think of AI generated works as something like a new public domain, what concerns me about, and it could be, what concerns me is AI is able to generate such an ocean of material. It's a voracious reader, but it's also a prodigious author. And I could imagine the situation where AI is just generating, a vast ocean of content that might make it difficult for others to create new works. Something like that seems possible.
That's potentially unintended consequence. I was getting more at the. I'm going to turn to Chris now on the same topic. How would the Copyright Office know what was created by the AI? You've used the technologies more, or human. Are they relying on honesty, do you think?
Relying on what? I just didn't hear. Oh, honesty. Yeah. Yeah, I can't wait till we get to the examples. What's going on through my head as I'm, thinking through this, we're all thinking through this for the first time, really, right? And as you use the technology, the consistency of the output, like a single prompt can have multiple outputs, right? And then other prompts, which could be similar but also different, can have similar results, right? And so where do you draw that line is what comes into my mind as we're thinking about it.
I actually was specifically asking that when you're creating it, would there be any technological, for a guy who worked at Apple and understands that, is there any way to sort what's created by AI with a definite line between that and the human creativity if you submit a specimen?
Are we speaking strictly about prompts or the output?
So, sorry, we got a off mic here. You can use that. So when we send in a recording,
yeah,
we do this every week probably, and we say, here's the material we want it.
Is there a way to detect that it's AI?
Copyright. How would it know? If my wife, Carrie Newcomer, has written 300 songs,
yep.
What if she moves to AI creations and her next hit is written by AI and she submits it? How would they know?
Yeah, so I used to sound very biased when I gave this answer because I worked for the company I'm about to talk about, but I no longer work at PEX,
yeah.
PEX. So it's not a bias, but they've been focused on this for quite a while and identifying if something has been generated or not. And they do that through fingerprinting and then comparing the reference files with what has been generated. And it's a high degree of accuracy as to identifying whether something is identifiable as originating from generative content. So that's part one. Part two is they've also gotten very good at identifying what sources were used in that. Like when we look at that picture, for example, you could tell, oh, that's Van Gogh, Starry Night, right? It's much more difficult with audio and with music. But PEX has gotten to where that they can, and they're not the only ones, but in my opinion, they are the best, which is why I worked for them.
So so we have audible magic in the music industry, which can, and other technologies, which can take down immediately a sound recording from YouTube if it's not authorized. But that's because there's fingerprinted or identifiable pre-existing work. What if we're just prompting it to write a song that sounds like Gary Newcomer and Bob Dylan mixed with Van Halen, and then it creates something, and we've all done this on ChatGPT as a joke. Well, could anybody know that if there was no sound file or pre-existing work that it was actually using?
You would have to have the pre-existing reference, that reference database to compare it against, absolutely. And both of those files would have to be fingerprinted in order to identify.
And the scary thing is the Copyright Office is probably considering using AI to determine if it was created by AI.
And well, in fact, that's the only way to do it.
Okay. Marshall, any thoughts on this before we move on to the next? This is the protecting works that are being created by humans with AI use.
No, not really. We can refine this enormously, but we have to make decisions in a practical way when we fold this into what the Copyright Office, for instance, has to do in determining registration. This has enormous consequences. We got to come up with some pretty well-defined rules. But one of the problems that I see in the Copyright Office's Copyright Office's decision on these matters is that someone can say, well, I did a lot of, add a lot of human content to this, and maybe they didn't. There's an enormous room for fraud here. I think this relates to your question itself. How do you determine can there be computer programs in themselves that determine whether this is to what extent the computer is operating on its own behalf, or whether there is human input. I'm not versed enough in the technology to really come out with anything interesting to say about that, but I'm sure there is a process of doing it, and maybe Chris has kind of indicated a little bit along those lines.
The consequences of not being able to get a copyright on something are one thing. Let's go to the other side of the coin, which a lot of creative people are thinking is the doomsday scenario. That's AI being used to scrape and train off of their creative works and kind of take over the creative industries. So my question to Marshall or Michael to get us started is, can you explain fair use? There's a lot of non-lawyers here, and then we can jump into whether fair use might be applicable as a defense in these. There's some 20 cases pending right now.
Well, but Robert, I can try to do this. You're giving me quite a challenge here so I don't rattle on for about an hour, but I can
fair use in 60 seconds.
I got 60 seconds. It's like saying, well, War and Peace is something about Russia. Anyway, no, the concept. This is quite a challenge, but fair use is an affirmative defense to copyright infringement, and the person asserting the defense has to prove it. The Copyright Act really helps us out a lot, because in Section 1 helps us out to a certain extent, because in Section 107, fair use is codified, as Miriam indicated. And I think that to understand fair use, you have to take a look at for the sort of the policy behind it. And if you look at the preamble, the preamble to fair use said that this non-exhaustive list, which is typical of fair use, includes the purposes of criticism, comment, news reporting, educational uses, and the like. But it's an open-ended kind of defense, and it's very flexible. That's one of the problems that some people have said, that this is probably the most troublesome issue in all of copyright law. But I think that you got to look at fair use from kind of a generalized standpoint. It's I like the quote from a case. That the judge said the doctrine of fair use permits courts to avoid rigid application of the copyright statute when, on occasion, it would stifle the very creativity which that law is destined to foster. And this is, I think, probably the essence of fair use. And you can take a look, and if I don't want to go on too much longer. Really cut me off if I'm belaboring this, but there are a couple of cases actually which I think relate very specifically to the problem of particularly the Gen AI. One of the cases that found fair use was a case called Sega versus Accolade. I think it's very pertinent to fair use. Well, in the Sega case, the defendant here wanted to make a game that was compatible with the Sega platform. In order to do so, it had to copy the Sega platform to learn how to make it compatible. Well, anyway, when you copy, you're committing infringement. And it copied the whole platform, and it took it apart, and it figured it out, and then it produced the game. Well, the court said, even though that's copyright infringement, fair use would apply, because what's happening here is that Sega is not copying just for copying's sake, but copying to learn, copying to make something compatible, copying to give a new product to the public. And so the court says that if you apply the fair use principle here, that certainly this should be not a copyright infringement. And the EU has a very similar kind of rule on this as well. But I think this is a good example for the Gen AI situation, because what are these programs doing when they scrape and they use databases to learn how to produce another work? They're doing the same kind of thing. This is called intermediate copying, not copying for copying's sake, but to do something which is beneficial to society. So in that sense, you could make a very strong argument that simply the Gen AI, which is learning from other people's copyrighted works to produce their own work, much like we do in our own lives to produce our work. We read things all the time. Tunes are in our heads, and we learn from these, and we produce our own copyrighted material. So that would be the argument. Miriam,
let's hand over to Michael for 1 second, but I want to just say the very simplest digestible version of it is there's 4 factors they give in the Copyright Act that you're supposed to look at. And the first is purpose. What is the purpose of your work? Are you transforming it in some valuable way to society? Then the second is the nature of the underlying work. We can throw that one out now because these works are very highly valuable: songs, movies, books. Amount of work being copied. That one kind of is easy to see too, as you're copying all of it. Although they may argue, like Google Books, that it's not all being used in the end product. But the last one is the market effect. Are you hurting the market for it? And my question to you, Michael, I think it's clear that the purpose and the market effect here are probably the deciding factors, wouldn't you think? And how do you see scraping entire catalogs of the Beatles to train your AI music, and Chris too? I'd like to hear you. Do you think that purpose will and market effect will win or lose for the technology companies using those scraping techniques?
Yeah, so I think, first of all, those four factors are helpful to think of. Courts have to follow them, but they are like a soft picture of what might happen in reality. So courts, for example, have to look at the purpose and character of the copying. We imagine when we think about copyright infringement, we imagine usually a pretty simple scenario. Someone comes along, copies a song, and tries to make money off of the artist who wrote the song. AI might include something like that. So you could train an AI work on the works of Garth Brooks and then generate works that compete in the market with Garth Brooks. That's possible. But there are a lot of other things that training an AI on Garth Brooks, I'm choosing him arbitrarily. I don't know why. What, there are a lot of other purposes that you might copy his works for, and AI is capable of doing things that don't necessarily compete with his market. So, for example, AI has been very useful. Let's jump to the book industry. It's been very useful in the publishing industry to help publishers identify new works that might be worth publishing. So I've been researching how publishing houses, for example, are using AI to sort through the slush pile of submissions. Well, that AI sorts through the slush pile of submissions, finds the needle in the haystack by having read millions of books. It knows the difference between something that's good and bad. So there are all of these funny uses of AI that complicate the normal simple picture. Rob, I think I danced around your question a little bit, but I guess I'm trying to get at how nuanced and difficult this is.
So I'd love to hear Chris talk once you're done, Michael, about, and we're going to listen to some AI assisted generated music, and shift into some questions about how we can protect against the doomsday that some musicians and myself included think may be on the horizon. But what do you think about just the nature of the fair use defense as a non-lawyer? Like, do you really think like the market effect, is it going to be seen by the courts, do you figure, to hurt the market for Garth Brooks or other artists?
As far as where I think we'll arrive at an opt-out. You can opt out of these models. As far as the impact that will have, I spend a lot of time with artists, with musicians, with composers, but also technologists. And the thread there is everybody wants attribution and everybody wants payment, right? And so I think everyone I realize how broad everyone is, but most everyone wants it. If you can guarantee or you can show a way to attribution or payment, and the technology exists, it is AI, but the technology exists to make that a reality, I think everyone is fine with that, Like in one of the examples we'll listen to is a hit songwriter, Ross Copperman. He has over 20 #1 hits. He writes a lot for Dierks Bentley, Kenny Chesney. I'm from Nashville, so and the song we'll listen to is 100% AI, and it is Ross's lyrics, but the voice, the instruments, everything about it is all AI.
We will listen to that just momentarily. Can I make a comment before we do? So again, to situate us, AI could copy styles or could copy specific melodies in infringing ways. But the other thing that people are worried about is that AI is copying name, image, likeness, and voice. And we're going to get to in just a moment the new Elvis Act, which many of you have heard of, just passed last week in Tennessee, where you're from. And we'll talk about how we're protecting against that possibility. But first, a real brief comment. It's funny, if you're a hammer, everything looks like a nail. And I'm hearing you, a guy that came from Apple, say opt out. And I'm a lawyer, and I'm saying we're going to sue their butts. And can they win on a fair use defense? And all jokes aside, where you are in the industry does color your view of this. And
Can I say one thing?
Yeah, and I represent musicians, so I'm like in the fighting stance. And the technology companies are more like, this could do good things for the world. And academics are in the middle saying, we're going to write a paper and just think about the theoretical possibilities.
So, and Robert, I think I have like 12 lawyers. Like, I love lawyers, right? I don't like paying them, but where I just want to preface that we need you is the whole reason I say that. But when I talk to folks, the musicians, and I would love to hear everyone's that's a musician here is generally for this advancement in technology and see it as a tool, as a creative tool with that. But it is the lawyers and the labels and the rights, the rights holders that didn't do anything to create really anything that
Okay, I hear Dirks Bentley coming. Shall we move to him?
Sure.
Okay, you have to explain which
Oh
one.
yeah, it's Wait for the Rain. It's that song, the song Wait for the Rain. So as they're pulling it up, I'll explain what this is. So what was that? Oh, okay, cool. Yeah, so Ross wrote this song, and Ross pitches, when you're a songwriter in Nashville, you probably know this, but you pitch songs and you do a bunch of co-writes and you want them to pick your song so that you get to pay your bills, right? So Ross has been using this. Well, it'll be really helpful for me to pitch to Dirks if I just use Dirk's voice, right? And that's what you'll hear here. Now, I will say when Ross and I were hanging out and talking through this, he was like, "Can I just release this? This is great," And I was like, I wouldn't do that, right? But using it as a tool with Dirk's permission, right? He trained it. Ross trained it himself using songs that he wrote with Dirk's, and so, am I stalling long enough?
Nashville winters can be so mean. Pewter skies and you can't find a piece of green. But we got each other, we got this key. So let's keep each other warm till spring. Baby, you can be my blue sky, I can be your sunshine. Together we can ride out anything. It's cold here in December.
I mean, what do you guys think about that? Right? That's impressive. Now I can show you some really bad examples too. But what I think is really important is you have an artist in Ross and an artist in Dirks that made that possible, right? Like, there are creative decisions being made in concert with the technology, right? And so I think that's where we're going to land. And that's why I use that to answer your question. What do I think will happen? I think, speeding up that process and churning out more songs is extremely valuable to a songwriter. Another example I'll use, I was so as songwriters, we do these things called songwriter camps. And basically a bunch of songwriters get together, right? And you break off into groups and you just churn out as much as you can. Well, I was at a songwriter camp, got stuck. We had a great verse, great chorus. We needed a good bridge. So popped the lyrics into ChatGPT and said, "Give me a bridge." I didn't tell the other writers this is what I was doing until afterwards. But then I was like, "Hey guys, what do you think about this?" Right? And they're like, "That's it." Right? All right. So who gets the attribution there? Right?
Yeah, over to Michael. But if Miriam's still listening here, I just don't answer this, but I just am just fascinated with the Copyright Office, knowing that much of the material that's submitted, like Chris just said, could have been created by ChatGPT, and there will be no way to know that. So just a note, what the Copyright Office has to deal with. Go ahead, Michael. Yeah.
First of all, I'll just say I thought that was amazing, that song. And I'm also worried that in about 5 years, I won't need to be here. There'll just be some hologram of me or something. But for now I'm here. The discussion that we've been having, has been bracketed and has been within the context of fair use. So we talked before about the fact that it's a defense to copyright infringement. It's relevant to this discussion of AI training. And there are 4 factors, right? Those 4 factors, Rob mentioned them before: purpose and character of the use, the nature of the copyrighted work. This is the heart of creative work, music. The amount that was copied, very often it's the total amount, and the effect of the use on the market. Now, there are factors that courts care about that are not formally listed there. And one of them is the overarching goal of the copyright system, which is to encourage the dissemination of creative works, to increase the amount of creative works in society. And these examples, Chris, you're talking about these examples of like, find me a bridge. It seems like that is furthering the production of a song and eventually its dissemination to the public. So,
Marshall, over to you to ask this question. Do you think when the Copyright Act of 1976 was written, they were talking about disseminating, the purpose was disseminate human created works? Or do you think they were thinking, oh, we're fine with the purpose including disseminating computer created works?
They had no idea. This is just science fiction to them in those days. And I was privy to a group that was very far-sighted called the Cantu Group, and that developed the provisions on computer software. They had no idea. They would have no idea. It would be crazy to them to even talk about this. The humans were, that's it,
Yeah, so that's an interesting argument, and there will be papers written on that if the assisted creativity has any part of what the original purpose was. It's curious.
As long as there's a paper at the end of the day, I'm happy.
But I think this gets to a much larger question ultimately, and that has to do when this report comes out and when Congress has deliberations. What are we going to do with this AI stuff? I have some very definite ideas about that, which are probably wrong because technology changes so quickly that you look stupid when you come out with these definitive conclusions. But anyway.
We're just moments away from, before we take questions from the audience, we'll ask for kind of conclusions from the panel. But let's move to right of publicity a second. Michael, do you want to just give a brief overview of what that is? Because it's not copyright.
Yeah, sure. So the right of publicity is state level law, and it varies state to state. Basically, you imagine that you start a business and part of the value of the business is in your name, your image, your likeness. So you're like you're a celebrity. And the right of publicity allows you to sue someone who uses your name, image, or likeness for commercial purposes without your permission. So that likeness could be really broad, and it could include your voice, which is relevant to this discussion of AI-generated music. An important limitation, though, is that in, I think, most states, this is a commercial use that you can sue for. There are a lot of non-commercial uses, like the creation of memes and things that might include a celebrity's voice that could fall outside of the right of publicity.
If any of my students are here, and they should be, since we're replacing a class with this, or they'll watch it, a recording. On the final, a question that always gets missed by more people than I want to, I'm hammering it home this year, is that just selling a book with Marilyn Monroe's photos in it is not considered a commercial use. It's not whether you're selling the product, it's whether it's exempted as a creative work by the First Amendment protection. So you can't force somebody to get permission from CMG Worldwide, if you know that company that was created here in Indiana under the Indiana Right of Publicity Act in 1994, the longest postmortem rights in the country.
100 years, I think.
100 years. So we became an important state, and we know about this more than most states. California, New York, Tennessee are the other obvious important states. But it exempts right at the beginning all of these creative uses of name, likeness, photos, voice in creative films, in books. And that's because the First Amendment needs to allow you to use those things. What is not permitted without permission of CMG or any licensing agent or heir to a dead person or the living person is selling Ford trucks or putting commercials up for perfume or raising money for nonprofits with that person's name, image, likeness. The problem is that all these exemptions mean that you're going to not be able to sue. Bob Dylan won't be able to sue when they mimic his voice and put out songs that sound like him. Okay, if it's the famous case of Bette Midler and they're selling Ford vehicles, you can sue. But if it's just a song on Spotify, you won't be able to. So what did Tennessee do?
So Tennessee is
last week.
Yeah, they've just passed the Elvis Act. This is really recently passed legislation. It might be a sign of more legislation to come at the state level, but it provides protection for the unauthorized use of a celebrity's voice generated through AI. So Tennessee was the first to really attack this head on with legislation. Go Tennessee.
But not just through AI, it includes AI, but in the sound recordings, they kind of made an attempt to deal with the problem I just stated. Those exemptions rendered those laws, state laws, unavailable for plaintiffs in the cases we're talking about. Now in Tennessee, it's ostensibly actionable. So what do you think, Chris? I know you live down there. They've been talking about it, for months now. What do you think about that law?
Yeah, I think it's a good thing. I think it's really important. The S in the acronym of Elvis stands for security. And so it is an issue of security, as we've seen with generated images, right? And because it's an issue of security, I think that this part of the problem will get solved quite quickly, right?
And what do you guys think before we open up questions? And then in those questions, I want to hear more find a way, Chris, to tell us more about what you're doing on the ground or in your final solution statement here. But I'm wondering, do we amend current laws like they just did in Tennessee? Do we have new legislation, federal, perhaps right of publicity legislation like Miriam mentioned? Are we okay with contractual provisions, the click-through licenses? What do you think? Let's start with you, Chris. How do we protect creators?
Specific to the Elvis Act?
No, overall. This is overarching.
Oh, overall. Well, I love that you used Bob Dylan as an example. So Bob Dylan sued Hootie and the Blowfish, Darius Rucker, a while back because in I Only Want to Be With You, he said, Bob says I'm tangled up in blue, right? So Bob's like, hey, that's my line, right? So that I think is dumb. However, using Bob's voice without his permission is not okay, right? And so I think that the legislation piece of it, deciding what is right, what is wrong, what can you do, what can you not, and I think security is where you draw the line, and I think that's important.
I'm an academic, so I have I'm allergic to any simple answer that I might want to give to this issue. It's complicated. This is if you think there's a simple answer to this problem of AI generated creative work, there's something that you've missed because it's nuanced. So in the end, it may be a combination of technological solutions, contract stuff like end user license agreements, maybe new laws like this Elvis Act. And Marshall made this point a few minutes ago that I think is one of the most important points of this whole discussion, which is this technology is moving so quickly. It might be the things that we're concerned about today are irrelevant in 3 years or in 5 years. I mean, 2 years ago, people weren't really talking about ChatGPT, and now it's, taken over so many discussions. So it's hard to predict given the speed of technology too. But from a legal perspective, we have contract law, copyright law, the right of publicity, maybe competition law, which we haven't even talked about that much, the right of privacy, which we haven't talked about that much. Mimicking someone's voice could implicate that. There's an international dimension to this. So many stakeholders, the music industry, the public, lawmakers. So I've got no simple answers here. I think it's fascinating. I wanted to thank you for letting me join this discussion.
We'll have another half hour here. So I wanted to get the audience into the conversation. Marshall, rather than just asking open-ended, what do you think should be done? Let's ask that question. How do you think international law plays into this and conflicts between the different national laws?
Well,
and what's happening at the EU right now?
Well, as I mentioned the other day, I attended a big conference here. Everybody's talking about AI all over the world, and the WIPO is talking, World Intellectual Property Organization, the UN. People are talking about treaties and the like. The treaty process might be a one way to go, but the problem is it's so slow. It's not going to happen overnight. So I think that's not something of immediate attention, immediate concern. The things are happening around the world in other jurisdictions. Little New Zealand has a law which provides ownership rights to someone who creates a work by AI and has a duration of 50 years. I mean, there are all kinds of things going on. Even the UK has a law that was passed in the 1980s that covers production of that gives a right to the programmer or the creator over in work created by an artificial intelligence. But so there's just piecemeal. It's going all over. The Israeli government issued a proclamation. They have fair use like the United States does, exactly like the United States. And the Attorney General there declared that the scraping and training on copyrighted materials is definitely a fair use. Japan has the same thing. Using other people's materials for purposes of training is a fair use. Things are happening all over the world, but it's in piecemeal fashion. And so if we come back here 5 years from now, my gosh, the world have been so changed. I think we ought to keep this for the archives and play it again when we meet 5 years from today.
Marshall, I would suggest that the international treaty process is probably faster these days than the U.S. Congress passing new legislation. Well, in all seriousness, I think I would suggest that states will play a huge role here, just like California does with CAFE standards and automobiles. Tennessee, Indiana has played an outsized role with this law I told you about passed, and everybody wondered why Indiana, but once it was in place, they controlled the marketplace until the law was challenged, and they've been taken down a few notches. But if California passes and New York passes more stringent AI laws, let me throw to the panel real quick, and this is like a 2-minute warning for public questions, okay? So please line up over here if you'd like to ask any questions. My question is, do you think that could be the answer, that New York and California, like Tennessee, could start setting the standards?
Well, it's possible. We've seen that with other areas of law, like privacy. California passed a privacy law that was widely seen as sort of the model for other states to initiate similar or enact similar privacy laws. So we could see that those two states are such important centers of culture and art. So it might be a sign of things to come in other states. Other states might look to those laws in California and New York as models.
And so, privacy is a good example. We're 20 years on since the EU has passed legislation, and we still don't have, other than industry specific, children's online privacy, HIPAA, but we don't have broad privacy legislation.
Yeah, that's right. I mean, it's a patchwork of privacy laws still in the US. Congress has considered enacting like a data privacy protection nationwide again and again, and it's never amounted to anything. There was never enough political goodwill to create a U.S. federal data protection law.
Great. Let's get the audience involved here. First question.
Test this to begin with, and just mention that the one person that's not here is ChatGPT. And it would be interesting to see what ChatGPT would have to say about all of this. So anyway, what we're going to do is we're going to have one question from the hall and then one question from those of you online. So if you're online, please make sure that you raise your hand if you have a question.
Hi, thank you all for being here. Shout out to Tennessee. I'm from Jackson. You might hear it in my voice. I don't know. But I am curious about AI and fair use policies. You spoke a little bit about copying something for learning purposes, and I'm designing something for beginning band classrooms. It's based on Black music culture and genres and Black gospel music. And I right now cannot pay a band to record play-along tracks like I want to. And so I'm working with AI to create something that's like Kirk Franklin or like a different Black artist for a play-along track for the band. I haven't released any of this because I'm not sure, you know, I don't want to get sued for that. And so does that fall under fair use to copy something for an educational purpose for a classroom use? Is it murky? Like, what does that look like?
I think, Michael, that'd be a good one for you to. I don't think my insurance policy will cover me giving legal advice here.
So in that case, I'll first say I'm not a lawyer. I was a lawyer, but I'm just purely a professor. It's not legal advice. In general, academic uses, educational uses of works have been recognized by courts as falling under fair use. Along with that, though, I'll say a caveat. Fair use is an unpredictable area of law, and it's very dependent on the specific circumstances of a case, specific, you know, to those 4 factors that we talked about before. So in general, yes, but also it depends on the specifics and also not legal advice. So, but it sounds like a fascinating project.
I'd say with a big disclaimer, this is not legal advice. Big thumbs up.
Yeah.
Yeah.
Me too.
Okay.
Well, I agree with everything that's been said, except don't sell it.
Are there any questions online from anybody? We have. Go ahead.
Yes, so we do have a question from Sean Burdett, who posted. I'm not sure if he's still here, but I'm going to read it for him. How would generative AI affect work for hire agreements, specifically when hiring artists to develop logos or art for company use? Should there be clauses in these agreements stating that artists should not use generative AI elements when developing content for a company? Along these lines, how does this affect trademarks? If a logo is designed for a company that they plan to trademark, what steps can companies take in our legal agreements with contractors?
Uh-oh.
Oh, that's fascinating. Yeah. So in general, you know, there's a doctrine in copyright law called work for hire doctrine. If you hire someone to create something like, for example, a famous case involving a sculpture that was commissioned, that sort of employment arrangement can, depending on the facts, mean that the person who commissioned the work is actually going to be the copyright owner, or through a contract with the person you've hired, you can claim that you'll be the copyright owner. Your question's great because we don't know the copyrightability of all forms of AI output. As Miriam explained earlier, the degree of human input that went into this, the interaction between the human author and the AI system raises all of these murky questions. So I could imagine that sort of clause being useful, writing into an agreement with someone who you hire, you won't use AI, so that we have a much clearer picture that you are, in fact, that this is a copyright we own and won't be contested.
So we just this week, we have an artist, a rock band, and their record label has given them a budget to make a video. And in the deal terms, it says you shall not use AI for your video production or editing in any manner. I interpreted that as nothing to do with ownership or work for hire. Maybe I misinterpreted it, but I thought that was a viewpoint from a business, ethical, creative viewpoint. Whatever it was, it is fascinating because a couple of things could occur. If you were an independent contractor creating a brochure or any artwork or any creative material for a company, and you used AI and you delivered it to that company, then the resulting work product may not be copyrightable, and they could build their business on that, and anybody could take it if it actually was created by AI and there was no copyright in it. That's one thing. But I think contracts generally will deal with it and say, we own everything you give to us to the extent it is copyrightable, and you may not use AI if they want to put that prohibition in there. Chris.
This is not to be argumentative, but to show how deep this web can go. Like in listening to that, so I do a lot of work as a film composer, and I will often use AI to master the music, right? Like where I'm going with that is like a lot of the plugins that I use when I compose use AI. So you're going to go down this rabbit hole of except for this, or if you're doing this, or how about
well, but that's an easy one because mastering doesn't add any copyright to the work anyways. So anything, I think you could delineate and say that's just sort of like a service that's provided after the work was created.
So it doesn't affect copyright, but it does affect payment, because if something is mastered differently by the rules, I don't think it's a law, but by the rules that the DSPs, Apple, Spotify, etc., have in place, you have to create a new ISRC code, the identifier for that recording, right? And that's how a lot of, that's why you see so many like remastered, is because they don't want to pay you that.
There are about 10 different implications of AI being used in that process. That it is wild. Next question.
Yeah, so we can go to Slack for lots of those conversations, please. Yeah.
Hi, thank you for letting me ask a question. So as you mentioned the case in 1988, the Ford case about like simulate a commercial sound of a singer, and you show me the example of how you can just steal someone's sound. And I felt like there's a difference, like it raised me a question about the fair use, because AI is now getting better and better, and it's easier to steal one's voice so quickly. And I don't know if in the future, maybe next year, you can just, process a sound of Taylor Swift singing an Adele song in like 5 minutes, and people can predict that as fair use because it's not using commercially and stuff like that. So my question is, isn't gonna be make the singer's voice less valuable in the future? Like if that's just more authentic, and how you guys think the law gonna travel this like in the future? Thank you.
I actually think, great question, thank you. I actually think it makes the singer's voice more valuable, right? And again, to me, it always comes back to attribution, right? And the cases you're giving, or the examples you're giving, attribution is clear, and then it's up to Taylor whether you use her voice or not, and she, can decide with that. But if there is attribution, then basically the money and the credit should follow the attribution.
There is this, I wrote down, I think Miriam mentioned the possibility in passing of, in the law, we have things like mechanical licenses are compulsory, meaning we can cover any song. I can do a Beatles song now. I just have to pay now. It's 12.4 cents per physical CD sold. So there could be, Michael, what do you think? Some compulsory nature to copyright law, or right of publicity for that matter, where if you use something of another artist, then you reduce the transaction cost. You don't have to negotiate it, but you have to pay a toll.
Yeah, so there's a few solutions to this problem. First of all, just if AI training, I'll talk about that for a moment and then get to this issue. But training an AI can require showing it millions, tens of millions of examples of, let's say, a song. That's how AI learns, right? Under the current machine learning models. So one problem is, how do you get, if we live in a world where you need permission from every copyright owner, how do you possibly aggregate all those permissions? You can't approach all of the copyright owners individually. Transaction costs would be through the roof. So one solution is a collective licensing pool. All of the copyright owners get together and offer a one-stop shop for licensing all the training data that one needs to train an AI. Another solution would be statutory. You have, as we do in another part of the Copyright Act, a rule that says you can use these works, you just have to pay a statutory fee. People in industry traditionally like the first solution better because they get to set the rate and don't trust lawmakers or other instruments of the state to set a statutory rate that's good. I also agree with Chris. There's opportunities here in the case of Taylor Swift's voice being used. There might be new markets for celebrities to license the use of their voice. Taylor Swift probably wouldn't do this, but other celebrities might license the use of their voice to sing a happy birthday at a birthday party or something. And that's a market that doesn't exist now. And it's also possible that AI will generate voices that compete with some artists. So it seems like both are true. It might create new markets for performers and also threaten existing markets too.
Marshall, just to get you involved in this, there's an in-between statutory, like the 115 mechanical to be able to cover other people's music, and open market negotiations, which are very slow and tedious. What's in between? I'm thinking of BMI and ASCAP, blanket licensing by the industry. You want to talk about that for a second?
I don't know. We're talking about political questions here, which are quite complicated. I mean, how are you going to strike up a deal on something like this? I'm a little skeptical at this stage for some kind of solution of that nature. This compulsory license situation here, at least in today, we might not say the same thing 5 years from now. It just doesn't seem like it's a practical solution from a whole host of technological and political aspects. One thing I think is interesting from this conversation, however, is that the actual licensing itself and licensing your AI persona has already begun, has it not? I mean, this is a reality, and perhaps this will take some of the edge off of these questions.
Just really quickly. So my point was that composers and publishers opt in to being in the catalog of BMI works, and then Indiana University at the basketball game at 5 o'clock today, or wherever it is, not here, unfortunately, the band can play that music, or in the Bluebird nightclub, or on radio stations. So there are ways the industry can work, and people can say, if I get paid, you can use my voice, you can scrape my music. Perhaps. I am more optimistic than you are, but it's what money is going to be earned.
Well, yeah, but I mean, the compensation aspect of this, and the problem with these compulsory licensing situations like the BM, like we've talked about, is that the costs are enormous, and they rake off so much of the revenue for the artists themselves that it doesn't seem, I don't know, at this stage, I'm a little skeptical about that.
We've got
quick Mike, and then we'll do one more question.
I'll jump in with a quick point. If we live in a world where training an AI requires licensing through one mechanism or another, the copyrighted works, that'll be the training data, there's a risk that that is a limited set of works. And in fact, the AI is going to have a biased view. So if you ask an AI that's been trained on a very limited set of works, that which its trainers had the availability to license, the AI might reinforce historical biases of all kinds.
We have another online question.
Yeah, we have Michael Suttle. Michael, do you want to open up your camera and speak?
I think my camera should be open. And can you hear me?
Yeah.
Okay, well, just real quick, I've got a comment, not a question, and maybe food for thought, and just a little bit of where I'm coming from. I'm a Jacobs School of Music graduate, 1975, so I've been around a while. 25 years VP of Sales Enterprise Software, still a performing professional trumpet player in California. And starting in the fall, I'm going to be visiting lecturer at the new IU Jacobs and Kelly new degree program in music business. So pretty exciting. And my comment is this, kind of like, does anybody remember Napster? Because they threatened they threatened all recorded music because of the technology revolution that made this possible from a technical point of view. And in my view, laws could not protect us from this, but commercial considerations did. And I'm a business guy, not a lawyer. And the power of the market, because it's still a B2C market. Mainly music is all about B2C, means consumer, right? Where it's the listener. And the market power, Steve Jobs and Apple created iTunes, and they sold what I would call virtual 45s for $1.99, which was low enough that it crushed Napster, but it was high enough that the musicians and creators made money. Now, there's probably an argument that maybe they didn't make enough money, but they made some money. And then other businesses sprouted up from this. And I just wanted to make that point and offer, food for thought on this, that I think the cavalry is coming from the Kelley School of Business. There's a commercial solution to these issues.
Yeah, before Apple stepped in, the lawyers did crush Napster, for the record. I mean, that's a fact. And fair use did not even come close to working. We teach that case. And IU, along with Yale and USC, in 2000, remember, Marshall, was sued by Metallica. That was one of the fronts on the legal assault. And I get your point that everybody lamented that it took so long for Apple to come in and finally streaming services, and that's a whole nother conversation. But the laws did work to prevent free exchange because it hurt the market so badly. So it may be a combination of business.
A combination. I'm good with a combination. I'd like to follow up with you on that. Thank you.
Good.
Hi, my name is Miggy Torres. I am a composer from the Jacob School. I've been really impressed with how fast AI generated art has been becoming more and more sophisticated, especially musically. I was really impressed by the song that you showed. I just wanted to clarify like a few things about what you were showing us, and then I had a question afterward. So the lyrics were written by a human, correct?
As far as we know.
Okay. And it was trained on a corpus of the musician's pre-existing songs, or was it larger than that?
It was both, actually.
Okay. So the question I have, which is admittedly extremely glib, is if I wrote my own lyrics and just took the melody, took the harmony, took the rhythm, took the orchestration, and just released my own song in exactly the same structure, uncopyrightable. It's mine now. Can I sell it and then you don't get anything? Is that fine? How do you feel about that?
So now you're touching on my favorite subject. I'm sure as a composer, you studied Schenkerian analysis, right?
Yeah. Is it all just 5-1 in the end?
What's interesting about Schenker is, he described 5 elements of music, not counting lyrics, right? Sound, harmony, melody, rhythm, and growth. We call it Schmerg. It's easy to remember. Correct me if I'm wrong, but copyright, at least here in the US, is just melody and lyric and sometimes rhythm if you're Queen and everybody's doing stomp, stomp, clap, right? Right. So why, if we have the ability to identify the sonic elements of music, obviously the melodic elements, the rhythmic elements of music, the growth, how it grows and expounds and develops over time, why are we not implementing that technology and using that to determine, hey, what is the unique combination of these 5 elements? And that is copyright.
Really cool idea. Thank you.
We started a little bit late, so if we have one more question, he's been waiting. I'm fine with, or whoever.
Or we maybe have somebody online.
Okay,
we have somebody.
Let's do them both quick. Yeah. And that AI camera is
Inarda McAllister.
That AI camera is showing us the future of our world. If you've been watching it,
right? Exactly. Yeah.
Hi, can you hear me? Okay.
Yeah, we can hear you.
Great. Hello. So there was a topic earlier that made me think of how easy it can be for information to get lost in the process of creating it, between the process of creating an original piece of music to the point that it has been used to train an AI model and generate content. I wanted to ask if we could elaborate more on how metadata is crucial in preserving the relationships between works and creators all the way through that process. Hi, Chris.
That's Anarde. Anarde and I used to work together at Naxos, if you know Naxos, the largest distributor of classical music. And what E is referring to is, so let's say with the Dirk song, right, it's Waiting for the Rain, right? Well, let's suppose that one distributor has it as Waiting in the Rain, right, instead of Waiting for the Rain. Even that little bit of change in metadata will get different rights holders paid than who was supposed to get paid, right? And so there is an important data element in this. There, with classical, there are over 1,400 variations of the name Tchaikovsky, right? There's over 12 versions of just Jay-Z, the way he has his name in the marketplace, right? You know, so I obviously I'm biased, but I agree with you, Anarde, that the data piece should be a part of this. And it's also something that AI can help with, right?
And one final question.
Yeah. So in speaking about these protections for artists and like litigation and legislation that's sure to come, I'm curious, we talked about Dierks Bentley, who I'm sure has a team of very expensive lawyers and people who are looking out for him. How do we balance that with independent artists who are probably more at risk to make these mistakes and need more protection, but don't necessarily have the funds or the ability to find that?
This isn't a call out just because Tristra's company Rock Paper Scissors represents CD Baby in downtown, but those independent distributors, there you are. Those independent distributors are incredibly proactive at addressing this. And I mentioned the PEX technology. Robert talked about Audible Magic. All of these distributors are on their own dime using and investing in using those technologies to help folks like yourself and me, right? Independent artists. I think my biggest concern when it comes to the independent community, yes, you talked about Dirks's legal team. My biggest concern is how, as things get caught up in this web, how that impacts the independent community and stifles creativity, right? When the technology exists to attribute and to pay, let it through. They can opt out. Let it through so that you can create the next song that Dirks writes or sings, right? Like that's it's a great point you bring up.
Chris, hope you'll forgive me, but that sounded like a great final statement from you. I'm going to move over to Michael and Marshall and ask for just final statements.
Well, first I'll just say what I said before. Thank you for inviting me to be part of this talk. I found it fascinating and the questions were wonderful. I will come back to the point I made a few minutes ago that the technology is moving so quickly that this conversation is likely to look different in 3 or 5 years. And I wish I knew where this was all headed. It feels like we're just in the beginning of the early days of the internet or something. Felt like this, where there was all this new technology. We knew it was important. We knew it was going to affect society and culture and art, but we didn't know how. And it feels like that's where we are right now. So I feel a lot of uncertainty. And I do feel concerned based on the last question. There's a power imbalance taking place too. There are voices that are likely to influence the direction of technology and policy, and then voices that are likely to get caught up in the shuffle and not heard. And it might be those voices that we have to focus on most. So I'll end there.
And Marshall, in French, your final statement.
Yes, well, just 2 things. First of all, getting back to the practical issue of fair use, I wish this was taken off the table and we would have something definitive on that the training and learning from copyrighted works would be a fair use. That's something that's just a personal normative view that I have. Secondly, because of the fast changing circumstances, AI, and also its character of being really unique. It should be taken completely out of the copyright system. This should have nothing to do with copyright. There should be a sui generis kind of solution to this that should not be based on any should be based on some copyright principles, but generally it should have its own regime. And to have an AI work last for 95 years in publication, to me, seems to be absolutely absurd. On the other hand, we have to have a certain amount of protection for people who are creative in the AI industry, who invest in this, and we should encourage investment, and we'd encourage the dissemination of these works in a way that's reasonable. And so you have to balance these kinds of things, but it should not be a part of copyright per se. It should be pursuant to another legal sui generis regime.
Thank you, Marshall. And my last remarks will be just to thank Alain Barker from Jacobs School of Music. I love doing these building bridges between the schools. It doesn't happen often enough. There is a music business degree starting next year, and we're working with them, but that's mainly Kelly and Jacobs. And talk to us if you want to know more about that. And to Caleb Bayfruz, law student, 1L, who did so much, probably more than any of us, to get this to happen. Let's give them a hand.